Hello everyone, Andrew Reed here, and we're going to do part 3 of my study guide for the upcoming NCA exam on constitutional law in 2023. Let's go ahead and dive right into it. Today we're going to look at property and civil rights. We're just following along with the syllabus, looking at the hyperlinks, and I'm going over my case briefs and other notes right along with that syllabus. Okay, so talking about the exclusive powers of the provincial legislatures. This is coming straight from the Constitution itself, from Section 92. So in each province, this is what the province can do. Direct taxation within the province for revenue raising, borrowing of money with the credit of the province, establishment and tenure of provincial offices and appointment and payment of provincial officers, management and sale of public lands belonging to the province, timber and wood thereon, establish maintenance and management of public and reformatory prisons for the province, establishing maintenance management of hospitals, asylums, other than marine hospitals, municipal institutions, licenses to raise revenue for shops and saloons, taverns, etc., local works and undertakings, lines of steam or other ships that connect the province, lines of steamships between the province and any other foreign country, works that are wholly situated within the province for the general advantage of Canada. Incorporation of companies with provincial objects, solemnization of marriage in the province, property and civil rights in the province, and administration of justice in the province, including the constitution, maintenance, and organizations of provincial courts, both of civil and criminal jurisdiction, and including procedure and civil matters in these courts. Imposition of punishment by fine, penalty, or imprisonment for enforcement of any law of the province, and generally all matters of a local or private nature in the province. So we can already see there's a lot of overlap with Section 91, almost to a confusing degree. So let's go ahead and look how this overlap affects things, especially from a property and civil rights perspective. First case on the syllabus, Citizens Insurance Company of Canada and Queen Insurance Company v. Parsons. This is from 1881. So this case being so old that it is basically forming the first rule, so it's not citing other cases here. First issue we're looking at, whether the act falls into the class of provincial subjects in Section 92, and whether it falls in Section 91 also. And if it does, is the provincial power overridden? Issue 2, whether the act falls under the trade and commerce head of power of Section 91. So the rule is property and civil rights is only in Section 92, trade and commerce is only in Section 91. Closest thing to a rule for this case. Analysis here in terms of whether it's in both. This case regards insurance contracts, which contracts is enumerated in S92 as provincial under property and civil rights because civil rights is rights arising from contract. In cases where there is a conflict between federal and provincial, the legislators do not intend for the provincial to be absorbed into the federal. In those cases, it is the duty of the courts to define in the particular case before them the limits of their respective powers. And so civil rights or contracts are not broadly enumerated in Section 91. The second analysis here, the words trade and commerce were not meant in an unlimited sense because these are contracts within a single province. In this case at hand, this is not within the scope of trade and commerce of Section 91. So conclusion, the court held there was no conflict under the enumerated power of civil rights, and the court also held that insurance contracts did not fall within the scope of trade and commerce in Section 91. Next case on the list, a lot more modern, Chatterjee versus Ontario in 2009. So issue in this case, whether the Ontario Remedies Act, which authorizes the forfeiture of proceeds of unlawful activity, let's say that again, which authorizes the forfeiture of proceeds of unlawful activity, is ultra vires in Ontario because it encroaches on the federal criminal law power. The rule here comes from Canadian Western Bank. A court should favor, where possible, the ordinary operation of statutes enacted by both levels of government. And also from Reference Free Firearms Act, two aspects of the law must be examined: the purpose of the enacting body and the legal effect of the law. And finally, and next from Morgenthaler, the court, in determining its pith and substance, will look at how the legislation as a whole affects the rights and liabilities of those subject to its terms. And now, finally, General Motors, both provincial and federal governments have the equal ability to legislate in ways that may incidentally affect the other government's sphere of power. So with these rules and with these thoughts in mind, the government analyzes as follows, or the court analyzes as follows. Each level of government bears a portion of the cost of criminality, and each level of government therefore has an interest in the suppression of crime. There is nothing in the provisions of the CRA, which is the act before us on this appeal, that go beyond the redistribution of property tainted by crime, including federal crimes. The internal evidence of purpose suggests a credible intent to recover from the proceeds of crime in Ontario to get that to the victims and to the public. Otherwise, it would just go into the provincial treasury. So forfeiture is a transfer of property from the owner to the crown. Forfeiture does not result in the conviction of anybody for any offense. It's not a imprisonment. It's targeting property rights, according to the court here. So there will often be a degree of overlap between measures enacted pursuant to the provincial power of property and civil rights and measures taken pursuant to the federal power, criminal law and procedure. In such cases, it is necessary for the court to identify the dominant feature of an impugned measure. So in this case, the dominant feature here was clearly property and civil rights, and therefore these provisions were constitutional. Okay. Some notes. There's a reference here a little bit later on to a case multiple access, which said in principle there would seem to be no good reasons to speak of paramountcy and preclusion, except where there is actual conflict in operation, as where one enactment says yes and the other says no. The same citizens are being told to do inconsistent things. Compliance with one is defiance to the other. These are the conflicts in which paramountcy and other conflict in operations concerns come across. So until we have those conflicts, that level of conflicts, according to multiple access. Finally, the most recent case on this list, under this list, the Reference Free Securities Act, and this is just in reference. Issue being whether the proposed Securities Act, which was set out, falls out within the legislative authority of the Parliament of Canada. So the federal government had proposed a Securities Act, and this was asked, the court was asked, is this lawful? So, general rule. Whether a law is validly adopted under the general trade and commerce power may be ascertained by asking 1, whether the law is part of a general regulatory scheme, 2, whether the scheme is under the oversight of a regulatory agency, 3, whether the legislation is concerned with trade as a whole rather than with a particular industry, 4, whether it is of such nature that provinces, acting alone or in concert, would be constitutionally incapable of enacting it, and 5, whether the legislative scheme is such that the failure to include one or more provinces or localities in the scheme would jeopardize its successful operation in other parts of the country. These are not exhaustive, and they're not all necessary. This is just guidelines. This is from the General Motors of Canada case. The analysis by the court here, and this one is relatively simple and straight from the reference. The main thrust of this act, the Securities Act, was to regulate on an exclusive basis all aspects of securities trading in Canada, including trades and occupations related to securities in each of the provinces. Purpose of the act: implement a comprehensive Canadian federal regime to regulate securities, to protect investors, to promote fair and efficient competitive markets. This has already been done in the provinces and in the territories. So this act cannot be classified as falling within general trade and commerce power because its main thrust does not address a matter of national importance, genuine national importance, and scope going to trade as a whole in a way that's distinct and different from provincial concerns. Canada, the government here, the Parliament, did not establish that the area of securities has been so transformed that it now needs to be regulated under the federal head of power. The preservation of capital markets to fuel Canada's economy and maintain candidate's financial stability, goes beyond the specific industry, engages trade as a whole. But the Act is chiefly concerned with day-to-day regulation of all aspects of contracts for securities within the provinces. Contracts remain essentially provincial concerns falling within property and civil rights in the provinces and are not related to trade as a whole. So conclusion, the Securities Act, as they put it out in this case, was not valid under the general branch of the federal power to regulate trade and commerce under Section 91. Okay, that's it for part 3. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.